Bob
Thank,
Battles.
thank you for being here.
Bob Battles Association of Washington Business. We're handing out a letter that we put in response to the current draft, and so my explanations and my discussions here will be based on what that current draft is. We do not know what will be changed on December 11th, but based on even the presentation today, we anticipate many of the same concerns. So a lot of our presentation from the business community has really been based on some very basic requirements and standards that should be taken into account. That, you know, the scope of these regulations is limited to what the statute should allow. We also believe that the department has no authority to deviate from the Washington State's legislative intent, and that the EAP exemption must mirror the Fair Labor and Standard Exemption or Act's EAP exemptions. That's what the legislature intended, this legislature. We all agree that the current standard that's out here right now is too low. It doesn't meet even the federal requirements. We all agree that when the federal requirement starts on 2020, that we all are going to be paying the 2020 requirement, or the federal requirements. We believe that there needs to be a consistent between both the federal and state law. We also believe that we should only amend to the extent there is a need demonstrated under the statute, and that there needs to be a cost-benefit rules to require evidentiary justification for deviation from the federal law. In this case, the department is doubling what the federal is going to. Because what you didn't see in that chart, or what you saw in that chart was put up there, but that wasn't pointed out to you, is come 2020, it's going to be about $680 a week for the federal rule. At the end of this rule implementation, it's going to be $1,535 a week. That's estimated on what the increases will be, and then it continues to go up. So we are doubling what the federal government is doing here. We are looking at a rate that is going to set this, the requirement for overtime, as you have to pay somebody nearly $80,000 before they're entitled to exempt status. What is happening here is this rule will still set the duties test, but now creates an arbitrary line in the sand of nearly $80,000 to say, even if you meet the duties test, even if you meet the requirements to be exempt, you can't be exempt. And that takes away flexibility. That takes away the ability to, again, for that person that would have been exempt to be able to take off and do those activities for family. It takes away all of the different things that come from having an exempt salaried status position. And so therefore, we are opposed to the way the rule is going to be likely to be done. We have concerns with this rule. I think our letter kind of clearly explains it, but I want to turn it over to Jan G., who has, I think, some more specific explanations as to many of the specific industries and how this is going to affect them.
Thank you.
Hello, I'm Jan G. with the Washington Food Industry Association, which is the independent and convenience store industry. And today my comments are generally on behalf of our industry, the restaurants, and the retail and hotel motels, as we're all working together in the same industry, and we all face the same challenges with this rule. I would like to commend L&I for giving a more clear and concise definition on the duties provision of it, but the threshold salary is extreme, very extreme, when you talk about the industries that I'm speaking upon. And I don't think that Labor and Industries took into account all of these industries throughout the state. We're all high volume, labor intensive, and we are among the lowest profit businesses in the state. Most of us are open 7 days a week, 18 to 24 hours a day, and it takes a whole lot of managers and mid-managers to keep our business operating. Attached to my testimony is a 2018 salary survey of the independent grocery industry, and it breaks it down by all of our departments and mid-management. And you can see that we are going to be very, very impacted by what is currently the proposed wage salary. All of our industries provide a lot of entry-level job opportunities, training on the job, opportunities for promotion and advancement and further education. And with this type of salary level, we will miss a huge section of our mid-management opportunities for employees. We provide very flexible hours, and that's a lot of the reason our mid-managers and managers like to work for our industry. We are highly price sensitive, so just raising our prices to cover this is really not an opportunity for these industries. I'm particularly concerned for our rural communities, where the wages are lower, the labor pool is much more reduced, and I'm concerned about this creating more food deserts in our state with our independent grocers. This state is driving a knife through the hearts of smaller independent businesses with the pile-on mandates we've had the last few years. We have $1.50 increase in the minimum wage coming up in January. And to see this as another pile-on is devastating for us. Please, please, let our employers operate and provide jobs both in the Puget Sound region, but in rural communities also. You know, we were at every hearing. Our members testified, our staff was there, and the overwhelming number of incidences that were reported by those people advocating for this was all about job duties. You have to meet the job duties before you even talk about the wages. And I came to the conclusion that our state's done a very poor job of educating both employers and employees of job duties, and then we look to the wages. So I would hope that labor and industries will be consistent with the federal rule, and I hope that we can dedicate a lot of resources to educating employers and employees. You gotta meet the job duties first. So I've also attached a letter for Representative Ormsby from Rosars, who was very active in the hearings in Eastern Washington. A lot of their people showed up because their employees are concerned about taking away their flexibility, their family time, making sure the store is open when there's a snowstorm coming in. You know, there are a lot of life episodes that affect our businesses. And we have great managers and mid-management that allow us to operate effectively to provide you healthy and fresh food. And we ask you to please, please work with labor and industries to give us a reasonable rule. Thank you very much.
Thank you very much. Are there any questions? Representative Gregerson.
Thank you, Mr. Chair. Can you expand a little bit on what you mean by job duties and who you're putting the blame on? Are you saying that workers are lazy? What are you saying?
No, I think what if I remember no, the EAP requires, it's a two-part test. The first part is, do they meet the duties? Do you meet the requirements to be exempt? And it is a set requirement in the rule. It's also in the federal. One thing that's been good about this rule-making process is we are aligning closer the federal and the state rules so that they match. That's the duties we're talking about. You must meet that. So regardless of what your salary is, if you don't meet that, you don't meet the EAP exemption unless you're this highly compensated. Then we're talking a whole number that's a whole different number in the rule. So you have to meet that. Then you go to the salary. The original purpose of that salary threshold was to create a line that says, you know, below this number, it is unlikely that anybody below this number is going to be doing those types of duties. So we're just going to arbitrarily choose that. What we've chosen here is a number that's much higher, and there will be a substantial number. In fact, these 250,000 people they're talking about, majority of them would have met the job duties and do meet the job duties, but now they don't get to because of the thing. This will eliminate the ability to have exempt salary, which means that if you're going to go get to your kid's soccer game, you're going to go to a doctor's appointment, you're going to be putting in leave. And if you don't have leave, then you're not going. If you're going to go to a conference, and I'm going to send you to a conference to educate you, you aren't going to get to go to that conference because I can't send my hourly person there. And one other thing that was mentioned here is about that people are going to don't get benefits. That's not true. Most of these people are already being paid benefits. Most salaried people are getting the same benefits that the hourly folks are.
Representative Mossbrucker has a question.
Thank you, Mr. Chair. So 2 quick questions. One is, can you address strategies to absorb the extra costs for the independent grocers and retail stores because of this new expense? How would you do that? And then can you also address the inability, or if there is ability, to raise the cost of goods sold in rural areas?
Well, I think I did make comment to that because our stores, our independent grocers, are the ones that service the rural communities of this state, and they are usually the only store in town. And if they're not able to survive because they can't afford the wages or keep enough staff to keep the store open, that becomes a food desert. I ask my stores, what will you do? If you look at that chart I gave you, it shows that all the department heads will have to go on hourly. That is like the meat department, the produce, those areas will have to go on hourly. That means if we have a snowstorm coming in and our stores get jam-packed, that our manager will be on hourly. The department managers are going to be on hourly. They're not going to be bringing people in. I mean, we're not going to be able to staff our stores. Our stores have told me they're just going to have to cut out that mid-management level and move them to hourly. You know, people that are in mid-management and looking forward to the next level, they don't want to sign a timesheet. They like the flexibility. But there's no option with that kind of a wage. They meet the duties test. They supervise people. But there's going to be a lot of great job opportunities for people to grow that don't have college educations if this salary goes into place.
Thank you very much. Any further questions? Again, thank you for your time. We'll move to the next item on the agenda. Last work session, we had a work session involving discussions around mandatory arbitration. The business community didn't get a chance to respond to that, so we're adding in 10 minutes today for Tim O'Connell from Stoll Reeves to talk about the issue from their perspective.
Thank you, Mr. Chairman, members of the committee. Tim O'Connell with the Stoll Reeves firm here to talk with you about arbitration. I was told that the committee was looking for an objective discussion of arbitration standards in the state of Washington, and so recognizing that I've spent my entire professional career as a lawyer representing employers, I am nonetheless going to try and present you with a kind of Joe Friday, just the facts, sir, explanation of what we have to do when we look at arbitration in our state.
Thank you.
Starting really with the legal basis for arbitration, both under state law, and what we cannot get away from is that when we consider arbitration agreements, there is a substantial federal law overlay on this issue. I want to spend some time with what we see as common arbitration procedures, as well as enforcement. When I looked at the presentation that was made to you in September, that was one of my big concerns, is that it didn't spend any time addressing this issue, which from a practitioner's perspective is one of the most critical issues when we look at trying to either enforce or set aside an arbitration agreement. Those raise issues of waiver and unconscionability, important concepts in our state. And frankly, I want to end up with talking about what we see from our perspective as the prevalence of arbitration in our state and generally. First off, let's start with the legal basis. Arbitration is a matter of contract, and at the risk of boring you with first semester law school stuff, the elements of a contract: offer, acceptance, either performance or bilateral promises, and they have to be supported by consideration. And while I say this is basic law school stuff, it really is important to start there, because as the not just is arbitration contractual, but as a matter of federal law, we have to look at our state contract law principles here. So most arbitration agreements, and my understanding is that we're concerned here with pre-dispute mandatory arbitration provisions. We're not talking about arbitration under a collective bargaining agreement. We're not talking about arbitration in the court-annexed system for small disputes. We're talking about programs that arise either through consumer contracts or through when you enter into your employment relationship. And I phrase it that way because the large majority of times it arises at the commencement of employment, either when you start your employment with the business, when you buy the product and you opt into those provisions as a consumer. Most employees who enter into mandatory arbitration do so as part of their onboarding paperwork. And we'll talk about in a little bit some of the implications of that. That is, that it's just a part of the higher paperwork, because there's nothing really all that out of the ordinary about it. For those of you who have ever bought a new piece of hardware or software, that box that you have to click through, that I've read and accept the terms and conditions, very often those will contain a number of provisions that govern your relationship with whoever is selling you that product. Those are sometimes called click wrap agreements, because you got to click on them and you accept the entirety of them in order to proceed and actually utilize the product. Routinely enforceable. Those are sometimes called contracts of adhesion, and one of the things we have to remember is that there is nothing unenforceable about a contract of adhesion. And just to see how common they are in everyday life, the next time you go to any sporting event, I'd urge you to turn over your ticket and read the terms and conditions that govern your acceptance and your attendance at that event. These are indeed routine parts of life. But that's at the commencement of the relationship. It's not out of the ordinary to see arbitration or other terms and conditions get enforced during the midstream of an employment relationship or other form. And there's, again, nothing particularly out of the ordinary about that under contract law. And here in the employment context, which, as you know, that's mostly what I do, I draw your attention to the bill you passed a year ago, SB 6471. If you remember, that was a bill that directed the State Human Rights Commission to draft and promulgate model policies for investigating and dealing with sexual harassment. HRC has done so. And I'm sure no one in here has any doubt that if an employer was to utilize that HRC draft policy and adopt it as the employer's own policy, that policy would be fully effective on all employees as of the time it's adopted. There's nothing out of the ordinary about that. In fact, that's been Washington law for 25 years. The Thompson case made clear that in the employment context, the employer is at liberty to adopt new policies, and those are binding on the employees who remain employed. And that, again, going back to our first-year contracts language, there's nothing that offends the notion about mutuality and consideration for those, because arbitration is different than, for example, last session, when we were going through the process of adopting the legislation dealing with non-competes. We'll all remember that there was a provision that you can't impose a non-compete in the course of new employment. Well, that's because a non-compete is not mutual. It is just a benefit that the employee is giving to the employer. Arbitration is different. It's a mutual promise to arbitrate. Both sides give up access to court, just the employer as well as the employee, the consumer as well as the business. Everyone has to go. Now, I mentioned that it's important to keep general rules of contract law and principles in play because of a federal overlay. That's the Federal Arbitration Act. That's been the law in our country for now almost 100 years, enacted back in the 1920s. And if I had to summarize it in a clause, it would be this: agreements to arbitrate must be enforced, as would all other contracts in the state. Can't single out arbitration for disfavor, either overall as a matter of public policy. Now, that's not our concern. We have a plethora of Washington authority making clear that the public policy in Washington generally supports arbitration. But the FAA goes further to say you can't single out arbitration for disfavor And so I'll draw your attention to another bill that was recently enacted by the legislature, SB 6313. That bill, you may recall, purported to bar non-public resolution of claims of discrimination. Well, I mean, that's a problem under preemption. This is the Kindred Nursing Centers case. The Federal Arbitration Act preempts any state rule discriminating on its face against arbitration for a law prohibiting outright the arbitration of a particular claim. On its face, that would seem to apply to 6313. And indeed, I am aware of at least 2 superior courts that have indeed concluded that 6313 is preempted by federal law. And I am aware of no courts that have upheld 6313. And in all candor, that's the outcome I would expect. The Kindred Nursing Centers case, sometimes we look with some suspicion on decisions coming out of the U.S. Supreme Court these days. The Kindred Nursing Centers case was a 7-2 decision. The actual text that you're reading there was written by Justice Kagan, nobody's idea of a right-winger. Turn our attention to procedure if there is, in fact, an arbitration agreement that's been enacted. There's a variety of mechanisms in most arbitration agreements as to a selection of an arbitrator. There are numerous agencies and organizations, and indeed many bar associations can provide groups of potential arbitrators for selection. In the rules, what rules govern the arbitration? It's a question of what your arbitration agreement provides, and most careful arbitration agreements will specify either by incorporation or just defer to procedural rules that are defined by some agency. AAA, the American Arbitration Association, is an example. Most arbitration agreements provide for some discovery, but it's also not uncommon for most arbitration agreements to provide some limits on discovery. But again, when we contrast that with superior court litigation these days, that's not all that uncommon either. If you look at 2 of our largest courts in this state, both Pierce County and King County, by local rule, the courts have enacted limitations on discovery. For King County, where I practice the most, we have a presumptive limit of 10 depositions, limits interrogatories. Pierce County limits interrogatories depending upon the perceived difficulty of the case. And then arbitrations end up in an evidentiary hearing, and typically those arbitration hearings are more relaxed than the kind of rules of evidence and procedure that we see in a superior court. But again, that is not out of the ordinary, and we can know that by we contrast it with the statute that this legislature has promulgated for administrative agencies, 3405, that's our State Administrative Procedures Act. It is explicit that in those kinds of proceedings, the rules of evidence are not strictly binding, and in fact are guidance. And I would suggest that most arbitrators take the same tactics. Most arbitrations, not all are not required to, but most of them will result in a written decision. I would say, in my experience, the vast majority of them will get you a written award of some type. The review of a labor arbitration is very limited, and we had just an example of that just a couple of months ago from our State Court of Appeals in the Mainline Rock and Ballast case, which made clear that as a matter of Washington law, there are very limited grounds to review arbitration. Indeed, really the only one that has any teeth to it is the notion that a court will review an arbitration award for legal error that appears on the face of the award. The Mainline Rock case is very interesting because the court wouldn't even look at other sections of the contract, even though the contract document itself wasn't in dispute, if the contract was not relied on by the arbitrator. Here's where, as I say, the rubber meets the road if you're a practitioner and you're faced with an arbitration agreement, and this is one of the things that I wanted to make sure to draw to your attention because your hearing in September didn't deal with this at all. There are several grounds on which arbitration agreements are not enforced in our state. The first is waiver, and that can arise in a variety of contexts, but essentially it's any time the party seeking to enforce the arbitration agreement engages in conduct that's inconsistent with complying with your arbitration agreement. Most typically what we see is a party who in litigation tries to take advantage of litigation, does extensive discovery, engages in motion practice, and then says, oh, by the way, now I want to arbitrate. Many times that will be viewed as untimely, that you have waived the ability to go to arbitration on that. The other major area, and this is something I want to draw to your attention because, again, it wasn't talked about. One of the general rules of contract law in our state is that our state will not enforce unconscionable contracts. Those are contracts that have terms that are unacceptable. And that's applicable to all contracts, and so therefore it is applicable to arbitration as it would be to any other contract. There's two general principles. Procedural unconscionability. That is, there is something in the formation of the contract that renders that contract unfair. We'll turn to some examples of that in a few moments. In addition to procedural unconscionability, there is also substantive unconscionability. That is, that there are provisions in an arbitration agreement that a court would look at as it's being overly harsh, one-sided, shocking the court's conscience. If that happens, generally speaking, the courts will not enforce those provisions. General rule in Washington law that if there are substantively unconscionable components, the courts will seek to sever those provisions, that is, enforce the remainder of the agreement, but not those parts that are unconscionable. Substantively unconscionable provisions, I heard a lot of discussion in the September presentation about the inherent advantages to one side from confidentiality to an arbitration procedure. I have to tell you, I actually argued this case 15 years ago, the Zuver versus AirTouch case. Our court has made very clear procedures, provisions in an arbitration agreement that would hold the arbitration process as confidential and not subject to disclosure. Those are unconscionable and unenforceable. And so concerns about confidentiality should not be a motivating factor. Similarly, provisions in an arbitration agreement that would seek to overturn our state's determination of who could be a prevailing party. The Gandy case is a Consumer Protection Act case. It's not an employment case. But that's a case in which the arbitration agreement seeks to overturn our state's presumption in the Consumer Protection Act that a prevailing plaintiff can recover fees. And our court said, no, that is similarly unconscionable to extend attorney's fees to a prevailing defendant, contrary to the Consumer Protection Act. A mandatory grievance process. The Pagliacci Pizza case came down just a few months ago. But any attempt to force a party to go into a grievance process, similar to what we might see in a collective bargaining agreement, but if we're trying to do that in just a single plaintiff claim, it would be unconscionable to force someone to go through such a process. Conversely, there have been a number of times when the courts have been faced with claims that provisions are unconscionable, and our court has said, no, that can be acceptable. Discovery limitations, again, a case that just came down a few months ago. Just because there's discovery limitations, where we're going to limit what discovery you have automatically, and then further discovery you need to get the arbitrator's approval of that, that doesn't render it unconscionable. As I said, that's not surprising because our superior courts have reached the same conclusion. A sanctions provision. A sanctions provision which gives the arbitrator the ability to control the proceedings before the arbitrator. That is, if you engage in unacceptable conduct, the arbitrator can issue some sanctions. The ability to modify the process. Again, we can change our contracts. This is one that always disturbs the heck out of me, but it's out there. A provision in an arbitration agreement that the parties have to represent themselves. You can't bring any lawyers. That's bad for my business, but it's okay according to the courts. And then one of the big elephant in the room here is the notion about single plaintiff proceedings. It is not unconscionable, said the United States Supreme Court, to have a requirement that if you're going to raise a dispute and you're going to have it in arbitration, you're going to do it by yourself and not through class proceedings. I referenced the Conniff case there because the Conniff case recognized that an earlier Washington decision that had held class action waivers to be unconscionable, the Conniff case recognized that that was contrary to a decision, a series of decisions coming from the United States Supreme Court interpreting the Federal Arbitration Act, and that those decisions had been abrogated. And CONIF has been pretty widely accepted by all parties as good law. Then there are a number of provisions that it depends on how it's being enforced. Private statute of limitations. You know, in a commercial contract, it's not unusual to establish that any dispute under this contract has got to be brought in a certain period of time. The Adler case from our state Supreme Court indicated that you can't use an arbitration agreement to unfairly limit a party's ability to make a claim. The Adler case had a contract of an arbitration provision in it that required the parties to bring any claim within 180 days. Now, of course, under our state law against discrimination, and Adler was an age discrimination case, under our state law against discrimination, you've got 3 years to present such a claim. And our court said that a 6-month limitation, 180 days, is unconscionable in that context. A more reasonable private statute of limitations might be enforceable. A venue provision. It's not uncommon, particularly for multi-state employers, to want to arbitrate these cases where they live, right? So rather than arbitrate it here where you're employed, we're going to make you come back to California or Virginia to arbitrate the case. A venue provision can be unconscionable because it can effectively prevent a party from presenting their claim. So it's a question of how it impacts the resources. And again, fee-splitting provisions may or may not be unconscionable depending upon how the parties are situated. I want to close by talking about whether there is a rush to arbitration. And in my practice, in my review, I think that's not quite so prevalent. This is an unusual slide. It's a slide of a slide, because the substantive slide there is one that I've been using for a number of years. There are pros and cons from a business's perspective about entering into arbitration. Yes, you get to stay out of court. Yes, under U.S. Supreme Court case law, you can use that as a way to make sure that cases are arbitrated individually. Yes, it's generally less expensive. But these days, if you have an arbitration provision, you're going to have to be sure that you're going to face an unconscionability claim, because our courts are very willing to consider those. And then I think you need to think about the fact that you're making it cheaper, you're making it easier, you're making it quicker. Is that going to generate more claims? Sometimes you get the stories ripped from the headlines. Just yesterday, in the Daily Labor Report, something labor lawyers look at, story coming out of California involving Grubhub, where they are now refusing to arbitrate claims because they were able to defeat a class action claim because the persons had signed arbitrations agreeing to individual arbitration. And now they're being presented with 2,200 demands to arbitrate, all of whom under their procedures have to go to the American Arbitration Association, which is a great organization, but candidly fantastically expensive. Even for a single employment claim, it costs about $2,000 in an administrative fee. So the Grubhub folks are looking at the fact they're looking at in excess of $4 million in arbitration fees before they pay a single arbitrator for a single day of hearing, and refusing to arbitrate. Respectfully, I think they're now in the situation where they're going to have been deemed to waive their arbitration procedure, and they're going to be back in a class action lawsuit. But arbitration is not the be-all and end-all for that. And then the last thing I would end with, this is what I tell my clients all the time. Remember that unlike a court proceeding, there is no meaningful review of arbitration. There is a reason why the word arbitration comes from the same Latin root as the word arbitrary. So you do have to be careful about whether you want to go to arbitration. And I think most employers in this state are. Those were my thoughts that I wanted to offer you about arbitration in this state. I'd be happy to take any questions if you have any.
Are there any questions? Most of the comments that I think we hear around some of the arbitration mandatory is, I didn't know it was in there.
You know, Chairman Sells, that is a great point. You know, I mentioned and didn't spend a lot of time on the issue of procedural unconscionability.
Yeah.
And that's a very real issue. If you have an arbitration procedure that is, I mean, here's the language, I can almost quote it, that you see in the cases, hidden you know, it's one paragraph in a 30-page employee handbook that you're issued on the first day of your employment, you may have difficulty enforcing that arbitration provision for just that reason. It's hidden. The cases we see where employers are able to sustain those, or businesses, is where it's not hidden in a massive fine print. Again, that's the kind of language you see. Most times, like the cases which I was just referencing for you, where arbitration agreements have been enforced, it's because the arbitration agreement is very prominent. It's in bold print. A couple of the cases, and in fact what I recommend as best practices, it's typically right above where the employee signs. And you have to make sure you don't use a lot of legalisms and Latinisms. You know, make it very plain what people are agreeing to when they agree to this proposition,
So it's not arbitrary.
so that it would not be arbitrary.
Thank you very much.
Thank you, Mr. Chairman. Thank you, members.
We're adjourned.